defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR. The other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond.
People? Or you're not concentrating on behalf of Mr. Floyd, who I believe is attending via Zoom.
State your name, please.
Mario Floyd. Yeah.
This is people's motion.
Yes, Your Honor. Thank you for the police report that I gave her in court this morning, but I know that she hasn't had the benefit of reviewing a lot of the discovery in the case. So I just wanted to put that on the record. And mostly, Your Honor, we're here today asking the court to reconsider the bond. In my written motion, I did indicate that the defendant is charged with a variety of extremely serious offenses, including but not limited to armed robbery, carjacking, assault with intent to rob while armed, larceny from a person, so on and so forth. My understanding is that the defendant is currently on juvenile probation related to his CHD. He has been non-compliant with that probation, most recently being put back into detention in February and released back out to his mother in March. And in this case, he was in Ann Arbor after midnight with one other individual at the time of the armed robbery, but with a group of other individual times later than the armed robbery, a group of 4 juveniles and 1 adult, ultimately an entirety of 5 people. I do believe that the likelihood of conviction is extremely high in this case, as this armed robbery and carjacking was captured on video from the Bell Tower Hotel. Very concerned for the safety of the community, mostly a bit concerned about the defendant's ability to comply with court orders, given his probation and non-compliance there. People do recognize the defendant is extremely young and will turn 18 later this month. But we do believe that the PR with the home confinement tether is an abuse of discretion. We'd ask the court to revisit the issue of bond. Happy to answer any questions the court has. Thank you, Your Honor.
All right. Scripture, I realized we were notified that you were being appointed to the case.
Well, Your Honor, because it's a tough question to answer, but I want to do my best. Okay. You reconcile it because he, in speaking to his mother and speaking to him, he understands the seriousness of this, and that's how you reconcile it. I mean, I get where the court's coming from, but this motion has to be, addressed. And, I appreciate the court listening to my arguments, but I think that there's other ways to ensure public safety. And that,
how do I not consider it an abuse of discretion where the co-defendant, as I'm to understand from the swear to, was standing between the victim in this case and the vehicle in a position that it's believed was going to stop the person from going to the vehicle, that this defendant actually pointed a pistol at the person, then struck the person with that handgun and took the phone. And this defendant did all of that. He has a PR. The other defendant who was standing there equally is liable for what's going on. But that person gets $100,000 cash surety bond. None of this, I'll be honest with you, and again, I'll listen to you, but I'm telling you from where I'm starting, none of this makes any sense to me.
well, I can appreciate the court's candor. The court's going to make their decision, and that's the court's prerogative to find an abuse of discretion. I mean, I don't have information as a swear to. I don't have the $100,000 bond that was set on the co-defendant. All I can say is that I believe it was Magistrate Odatello made that call, and he had the information. he had all of this information, I presume, because I haven't seen that video. I'm assuming, and
If the court would consider looking at a photo of this to see how realistic this looks, I do think it's important when we talk about this to realize that. If there's no objection from defense,
no objection.
it's not labeled or anything, Your Honor, and I'm not admitting it, but I just want the court to see the firearm that was recovered. This, I didn't say the weapon. I didn't say firearm. I should say weapon. In my experience, this looks like a Glock, Your Honor, and honestly, it is amazing to me how realistic it is. With no orange chip, it's completely black, the dark gray black. And the last thing that I will just let the court know, you know, I've already covered. I'll rest on everything I've already said. Thank you, Your Honor.
Anything else, Ms. Kirkland?
Just what I already said before, especially about the financial hardship of any high bond would produce on the family, Your Honor. Thank you.
The court, upon receiving the people's motion, they've indicated, read the motion, reviewed the swear to. I also reviewed the arraignment so that I could fully understand what information may have been the magistrate may have had at the time that the decision was made. I tried to give deference to the magistrate's decision regarding this. I will be quite frank with you, it is impossible for this court to do that in this case. The bond as set in this case, with all due respect to the magistrate, it's illogical to me. It makes no sense. It involves some of them juveniles. And so that this not only is some isolated incident, but that this defendant may be involved in effectively a criminal enterprise that clearly would jeopardize and pose a risk to the community at large. I think it's, and it pains me to say this, that this bond virtually is illegal. Because, first of all, he's on bond and commits these offenses. Secondly, at the swear to, it was very clear that all of the elements necessary given this charge, all of the elements there regarding the presumption or of guilt or the likelihood of conviction were there, that quite frankly, I'm not sure why his bond was not denied. We don't, in a lot of cases, get to see that, or certainly not at the arraignment stage, wouldn't be able to make that finding that this likelihood of conviction is there. This one is very clear. He's caught on video. The specific question was asked by the magistrate regarding identification of these individuals, and the officer in charge was able to, or the officer swearing it out, was able to articulate specific things that pointed to this defendant and his cohort as the people that did this. I'm not making a finding of guilt, but I certainly on that low standard for the purposes of bond, I don't know how one gets past it, frankly. Was there something you wanted to say?
I wanted the record to be clear to Your Honor, because the type of probation the defendant was on was juvenile probation and on adult probation for a violent felony. It wasn't immediately clear to me when I filled out the bond form if I had a reasonable basis to ask for bond to be denied pursuant to that provision of the court rule. And frankly, Your Honor, and I apologize, I didn't have time to do the research to get it done. And I wanted to ask the court for what I knew I had an ethical way to ask for, which is why we did not request that bond denied for a violent felony, because frankly, I wasn't sure if juvenile probation and violent felony was going to work in the same way that adult probation for a violent felony would work for the purpose.
Yeah, I think I have stated everything I have stated on the record. I also will indicate I am not, well, I don't judge a bond based upon other bonds that are set. There is a bizarre discrepancy between the two individuals involved in this offense. And clearly, based upon what is being said, this defendant was much more clearly involved with the activities of violence and harm toward the victim in this case. For those reasons, and having reviewed everything that I have, I regrettably but don't have any other option but to say that the setting of a personal recognizance bond in this matter, given these charges, given what I know about the case, and having reviewed everything, is a clear abuse of discretion. The court will vacate that bond and will reset the defendant's bond. I will leave the conditions that were set by the magistrate in place, but in terms of the monetary amount, I will reset the bond in an amount of $500,000 cash surety.
Before we consider 18%, Your Honor.
I will not, and mainly also because I don't know that the defendant being on probation violating this, my opinion is he's not entitled to it, and I'm certainly not going to exercise my discretion to grant.
Thank you, Your Honor, for considering that. Just had to ask. No, thank you.
Thank you, Your Honor. I will also let the court know I need to schedule for probable cause conference in 6 days.
Yes.
And discovery continues in this case and the investigation continues. And I do believe that we may have additional information by the time for the probable cause conference where the people may wish to revisit bond and our proofs become even stronger to request that bond be denied entirely. I do think that's possible.